I call the honourable member Campion. Calder. I'm sorry.
Thank you, Mr. Chairman. It's a great pleasure to rise and speak on this part one of this bill. Part one of the Courts and Criminal Matters Bill, as we heard, involves amendment to the District Courts Act 1947. And the whole purpose of this bill, an omnibus bill, and amending a number of statutes, is to enhance the court's powers and processes for the collection of fines and other monetary penalties and civil debt. We realise, of course, that most New Zealanders, if they err, do pay their fines, but there are a number who don't. And this is designed to deal with that rather significant problem. Part one, as I say, is involved amendment to the District Courts Act 1947. The principal amendments are to Part 6 of the Act, and this is involving enforcement of judgments, and these amendments are designed to improve civil debt enforcement processes. The civil enforcement system can be complex, cumbersome and costly for all parties. It generates high levels of tension and frustration among users, and attachment orders, which entail mandatory deductions from wages and benefits to pay debts, are actually the most effective civil debt enforcement option. Currently, an attachment order can only be imposed after an examination hearing has been held to assess the judgment debtor's ability to pay the debt, and both parties have to attend the hearing. Part 1 of the bill amends the District Courts Act to provide greater flexibility of enforcement processes, particularly in the establishment of the said attachment order, gathering information on a judgment debtor's means to pay the debt, removing geographic restrictions and modernising service provisions. I'd just like to briefly mention the concept of attachment orders and what we're attempting to do here. Clauses 13 to 18 amend a number of provisions in the District Court Act that deal with attachment orders. And these orders will be able to be issued following application for an attachment order and the filing of a financial statement or a financial assessment being undertaken. Unlike other enforcement options, attachment orders will be able to be issued immediately after a judgment or order has been made, and this will expedite the process and reduce cost to the parties. Another important part of this amendment is removal of geographic restrictions. We remove the amendment removes geographic restrictions to allow court processes to be undertaken at any district court rather than at a specific local court. Clause 10 inserts new section 79A to enable a judgment to be enforced at any district court, while Clause 8 repeals section 69, which regulates the removal of a judgment from one court to another. Clauses 5 to 7 make the necessary consequential adjustments to the powers of register, deputy registers and bailiff respectively. This is, once again, for the convenience of the parties involved. Mr Chairman, I commend this part to the House.
I call